Today, we're digging into a really fascinating story about a homeowner, a huge tree, and the pretty messy legal battle that erupted over a crocked foundation. I mean, who's to blame when a tree on common property literally destroys your home? Well, let's find out. So just imagine this for a second. You're all set to start a big home remodel. You're excited, but then your contractor finds a massive problem that stops everything dead in its tracks. And here's the kicker. It's a problem that started outside your property line, but it is literally tearing your house apart from the ground up. So who pays for that? That is the exact question at the heart of this entire dispute. You know, when an experienced contractor like Ed Humston walks into a house, they just know when something's off. And the second he walked through homeowner Nancy Pope's townhouse, his gut screamed that something was wrong. And that instinct, it pointed to one single culprit, setting off an investigation that, well, it would unearth a problem way bigger than anyone imagined. Okay, so let's set the scene. It's the spring of 2021. Nancy Pope is ready to get her townhouse remodeled. But her plans? They're about to hit a major, and I mean very expensive, roadblock. So her tenants of 11 years had just moved out, and Ms. Pope brings in her contractor, Ed Humston. And during that very first walkthrough, he sees it. A really noticeable heave in the living room floor. The foundation was actually being pushed upwards from below. So the investigation kicked off with the usual suspect, right? A water leak. But as you can see, tests on the water and sewer systems, they came back clean. So on June 17th, they did something pretty drastic. They cut open the concrete slab, and what they found was just shocking. A massive destructive web of roots, which they traced back to this huge bottle tree on the HOA's common property, just a few feet from her home. Now, with the cause staring them right in the face, you'd think the solution would be simple. Get rid of the tree, right? Well, this is where the real conflict begins. The timeline of what happened next became the absolute pillar of Ms. Pope's complaint against her HOA. This timeline is so crucial for understanding Ms. Pope's frustration. Okay, so the roots are found on June 17th. Just 4 days later, she files a maintenance request. It then takes over a whole month for the HOA's own landscaper to say, yeah, you should probably remove those trees. But it's not until late August, we're talking more than 2 months after the discovery, that she's finally given permission to remove the tree. But get this, only if she pays for it herself. The tree finally comes down on September 7th. You can imagine, for Ms. Pope, every single day of this delay just meant more and more potential damage. And this quote, wow, it just captures the whole vibe of that initial communication. Ms. Pope is looking at an emergency situation, but the HOA's response, it was purely procedural. She was told to go to the management company and that her concerns would be brought up at the next board meeting. That formal, kind of detached tone really set the stage for the conflict that was about to blow up. So, inevitably, the dispute lands in an administrative hearing. First up, let's break down the case made by the homeowner, Nancy Pope. Her entire argument really hinged on one key legal concept. And that concept is negligence. You know, in simple terms, it just means failing to act with reasonable care, which then ends up causing harm to someone else. Ms. Pope's whole claim was that the HOA failed to use that reasonable care in maintaining its own property, and that failure led directly to the destruction of her property. Her argument followed this really clear, logical path, as you can see here. First, she pointed to the HOA's own rulebook, and this is a key point for any homeowner, you gotta know your bylaws, which says they have a duty to maintain the common area. The source of the problem, that bottle tree, was on that common property. She then argued the nearly 3-month delay in removing it was a breach of that duty, and that this inaction directly caused her repair costs to just spiral out of control. And this is the number that really puts it all into perspective. Ms. Pope wasn't just arguing over a principle. She was trying to get reimbursed for some very real, very costly damages. She claimed the HOA's negligence cost her a grand total of $28,487 in repairs and all the related expenses. But of course, the Vida Homeowners Association had a very, very different take on things. So let's look at how they defended their actions and why they believed they weren't on the hook for any of the damages. The HOA's defense was summed up pretty powerfully, I might add, in their attorney's opening statement. They didn't frame this as a failure of maintenance, no. They called it an uncontrollable act of nature. So from their point of view, this was just some unforeseen events, and the responsibility for all the consequences, that fell squarely on the homeowner. This slide right here really gets to the heart of the whole legal battle. On one side, you have Ms. Pope saying the HOA had a clear duty to maintain the common area. The HOA fires back saying they had no idea there was a problem. Pope claims their long delay was negligent. The HOA calls it necessary due diligence. And then the HOA introduces two critical new arguments. One, that a previous homeowner planted the tree, not them. And two, that Ms. Pope's own irrigation line was what made it grow so aggressively. It's a classic defense, right? Trying to shift the blame back onto the person making the claim. So, after both sides presented all their evidence and their witnesses, from contractors to board members, it was all up to an administrative law judge to make the final call. So, what was the verdict? This is it, the ultimate question. After all the arguments, all the testimony, all the delays, who was legally on the hook for nearly $30,000 in damages? Was it the homeowner or was it the HOA? Now, before we get to the answer, it's really important to understand the standard of proof here. In a civil case like this, it's not like on TV, it's not beyond a reasonable doubt, it's something called preponderance of the evidence. All that means is the judge just had to be convinced that one side's story was more likely to be true than the other. That's it, just over 50%. And here it is, the decisive conclusion, right from the judge's written decision. It is a simple, direct statement of fact that just cuts through all the noise and debate. A tree on the HOA's property caused the damage, period. This finding was the bedrock for the final ruling. And in the end, the judge found that the HOA had violated its own governing documents. Their duty, plain and simple, was to maintain the common area, and they failed. Because that tree was on their property, the responsibility was theirs. Nancy Pope won her case. This whole case is a really fascinating look at a specific neighborhood conflict, but it does leave us with a much bigger question. It forces us all to ask, what does maintenance really mean for an HOA? Is it just about trimming branches and mowing lawns, or does it also include protecting homeowners from the hidden, destructive power of something as simple as a tree? It's definitely a question worth thinking about for anyone who lives in a planned community.